Case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Spengler, and Ms. Higgs. And the people are represented by Mr. Bruckler, Mr. Orman, Ms. Pearson, Ms. Teach McGuire, and Mr. Edson. We are outside the presence of the jury. Let me follow up on one of the last objections that was made yesterday afternoon. I think it was the last bench conference that we had, but it had to do with a question related to the culpable mental state. And why don't we have Dr. Gurr actually step up for just a moment. Do you mind, Doctor? No. Thank you. All right, the record should reflect that Dr. Gurr has stepped out of the courtroom. I believe the question had to do with the culpable mental state, the capacity to form the culpable mental state, or at least part of the culpable mental state of the crime of murder in the first degree, extreme indifference. And the objection, as I remember it, had to do with the question being beyond the scope because Dr. Gurr had only testified about the defendant's capacity to distinguish right from wrong, which is the other part of the insanity test, but not about necessarily about the culpable mental state or the capacity to form the culpable mental state of first-degree murder, extreme indifference. And two things. Mr. King, I think, acknowledged at the bench that on direct examination he elicited testimony from Dr. Gurr related to the defendant's capacity to form the culpable mental state element of murder in the first degree after deliberation and with intent, or at least part of that. I think he said that he asked a question about intent and capacity to form intent or to act with intent. I don't have an independent recollection of that, but I took his word for it, and I take his word for it. Given that, I think that makes the question about the culpable mental state of a different crime within the scope of the direct examination. But even if he didn't ask that question, I still think it's within the scope because this witness performed a sanity examination in this case of the defendant, and even if she's only testifying about the one part of the insanity test that deals with the capacity to distinguish right from wrong, I still think it's fair for the prosecution to ask about the other aspect of the insanity test in Colorado. As you know, the capacity to form the culpable mental state is what used to be known as the affirmative defense of impaired mental condition. That defense has now been incorporated into that subsection B of the test for insanity. That's what became that second part of the test for insanity under the current statute. And impaired mental condition was defined as a condition of mind caused by mental disease or defect which does not constitute insanity, but nevertheless prevents the person from forming a culpable mental state, which is an essential element of a crime charged. That's from Cordova versus People, 817 Pacific 2nd, 66. I believe it was in Cordova also that the court said that both the defense of insanity and the defense of impaired mental condition are defenses to go to the, are defenses to criminal conduct, if you will. They both deal with mental state defenses, and I'm not finding the language here in front of me. If I find it, I'll let you know, but they both are similar defenses, and I think it's fair if somebody's saying, in my opinion, the defendant did not have the capacity to distinguish right from wrong. I think it's fair for an opponent to ask, well, did he have the capacity to form the culpable mental state, which is something, it's almost like a lesser mental state, if you will, than insanity. So in other words, all right, doctor, I get that you're saying he had a mental disease or defect that prevented him from distinguishing right from wrong, but was this a mental disease or defect that also prevented him from forming the culpable mental state? In other words, what is the degree of the effect of the mental disease or defect? What is the extent of the mental disease or defect? I think those questions are appropriate on cross-examination when someone is testifying about a mental disease or defect that is so severe that it renders someone incapable of distinguishing right from wrong. I think in that situation, the opponent is able to ask, well, how severe is it? Is it so severe that it also prevented him from forming the culpable mental state? Or is it not so severe that it prevented him from forming the culpable mental state, but that it prevented him from distinguishing right from wrong? So even if the question about intent was not asked on direct examination, I still think it's an appropriate area for cross-examination. And so I wanted to supplement the record in that regard. All right, is there anything else from the parties at this time before I bring the jury in? Mr. Brock? All right.
Yes, sir.
Ms. Hicks.
Your Honor, because I sort of made the initial argument with regard to D-TR-94, and the court followed up on that yesterday, and we asked for time to kind of let the court's ruling and comments sort of congeal in our heads before we respond. I'm going to respond to what the court indicated yesterday.
Was it 94 or 97?
Is it 97, sorry. And I understand that Mr. King made an alternative argument when he was at the bench yesterday, which was similar to my initial argument with regard to that video, which is that the statements of Mr. Holmes on that video with regard to hallucinations or shadows are simply not hearsay. And I understand then the court cited us the case of Toth versus State. I've had an opportunity finally to review that. You know, I would note that that case rises and falls on the issue that the statements at issue were in fact non-statements. They were sort of, you know, kind of gibberish, and so they didn't assert anything, so they couldn't be excluded as hearsay. But I would note that that case does specifically indicate that nonsensical, which are the statements at issue there, or delusional statements may be as clear an indication that the utterer is not in his right mind as physical signs or symptoms of bizarre behavior, and they can thus be verbal acts or words of independent legal significance which are not hearsay. And so after reading that case that the court cited and seeing that language, and this is the case that Mr. King cited to the court yesterday, which is a case out of the High Court of New York called People versus Rico at 56 NY 2nd 320, and that High Court in New York addressed an issue that's directly on point with our case, Your Honor. And the statements at issue in that case were statements of delusion by the defendant made to his mother. And what the court found there was certainly those are not hearsay statements. They disagree with the trial court's refusal to admit those statements because the statements were not offered to show the truth of the delusions. Therefore, they were not offered to prove that the delusion was accurate, i.e., that the defendant was actually seeing spaceships controlling the behavior of the earth. That was what the statements talked about. And since those delusions are not truthful, i.e. there are not spaceships controlling the earth, the statements were not offered for the truth of the matter. That's what the court ruled. They simply were not hearsay. So it's different than the Toth case, which addressed whether the statements were assertions or not. This case dealt with whether they were offered for the truth, and they were not. And that is what we are offering Mr. Holmes' statements about shadows for. They are not offered for the truth that there were shadows. The RICO case, that court found that those statements were relevant to show the state of mind of the defendant, the delusional nature of his state of mind. They were not hearsay, and that they should have been admitted. So we are asking the court to, I know that Mr. King raised it again when he also argued the alternative of 703. I know the court had ruled on that issue prior when I argued it, but the court did not have the benefit of the case of RICO, which I believe is directly on point. So we're asking the court to admit or reconsider or at least rule on Mr. King's additional argument with regard to these statements not actually being hearsay. And I know the court indicated yesterday that there was some concern because the court didn't have any information about, what was told to Mr. Holmes before the video was presented. But we can present that information through Mr. Gonglak, who took the video. We did not, because the court had not yet ruled on whether or not it was going to be introduced. But we can do that. I just don't think, and we would, but I don't think it's really relevant to the issue of whether these are actual hearsay statements. And the court also noted yesterday that the prosecution argued that 703 is not a rule that allows the defense to introduce other inadmissible evidence. But the bottom line is the court, we believe, incorrectly excluded them as hearsay and found that they were inadmissible under the hearsay rule. And so, therefore, that argument from the prosecution would not apply. I would continue to make all of my arguments with regard to this under both the due process clauses, the right to present a defense, the right to a fair trial, as well as Mr. Holmes' right to a fair and reliable sentencing hearing. And the court also made an argument yesterday about the fact that the prosecution wouldn't have a chance to cross-examine Mr. Holmes with regard to these statements. But I would note that the prosecution's introduced 22 hours of non-cross-examined testimony from Mr. Holmes. The defense seeks to introduce, and we're happy to even redact the video to just the portion with regard to the statements about the shadows that in fact are corroborated by evidence that we have already admitted with regard to his behaviors at Denver Health the night before, where he was actually hiding under the sheets. And I also disagree with the court's characterization that these are inconsistent with the statements from the Denver Health doctors. In fact, they are very consistent and corroborated by that. So the court's concerned about the reliability of them in the follow-up yesterday, I think, is unfounded. They are more in-depth, but they are corroborated by those two other pieces. And they explain why Mr. Gonglak went back and collected that particular video or looked at that video from that night. Because indeed, what Mr. Holmes had indicated to Mr. Bishop and Mr. Gonglak in that video, that he was hiding from these shadows, is actually represented in the silent video that Denver Health had played, where he is hiding under the sheets repeatedly, hiding under the covers repeatedly, trying to hide under the mattress when they take the sheets and the covers away. So that's my follow-up. Thank you.
All right, thank you. Any response from the people? It's not plugged in.
I'll just do it from the table.
Okay.
Your Honor, the statements that counsel has referred to regarding shadows and so forth at Denver Health are offered for the truth of the matter asserted. They are offered by the defendant to bolster his claim of suffering from hallucinations, namely these shadows. We have heard a lot of testimony from psychiatrists, some testimony from psychologists about these issues. These shadows are not a delusion under anybody's definition of delusion. If anything, these shadows would be a hallucination. And the defendant's statements about the shadows would be his recitation to his agents, i.e. his defense investigators, regarding his memory of suffering from hallucinations. The New York case that counsel cited for the proposition of delusional statements is completely in opposite, in that there is no assertion by anyone at any time during this case that seeing shadows would constitute a delusion under any psychiatric definition of that term, that they are in fact hallucinations. And a defendant's recitation to his agents of that he had suffered from hallucinations is hearsay offered for the truth of the matter asserted. There is no correlation to a statement to a mother about something controlling the earth or something like that, which would be delusional possibly under the definition of delusion that you find in the DSM or that psychiatrists testify to. The defendant is attempting to introduce hearsay, and regardless of whether we've introduced the defendant's statements, 1,000,000 hours of the defendant's statements, it doesn't matter. The hearsay rule is not a two-way street when you are talking about the statements of the party opponent and the statements of the defendant. We can introduce as much of the defendant's statements as we want because they are not hearsay when we introduce them. When the defendant attempts to introduce his own statements made to his own agents in the most possible testimonial form of hearsay, in that gathered by his agents for the purpose of presenting his statements in court without the opportunity to cross-examine, which is what he's doing, when that is the situation, that is hearsay and should be excluded regardless of whether we have properly introduced the defendant's statements as non-hearsay. Unless the court has any questions for me, that's all I have to say.
All right, thank you. I agree with Mr. Orman. First of all, I want to correct something Ms. Higgs said. The court doesn't make arguments. Counsel make arguments. The court makes rulings. In my ruling yesterday, not my argument yesterday, I was very specific about the grounds for why I was not admitting this exhibit, and my ruling stands. This is different than someone making nonsensical statements to a witness. This is an interview. In this case, the defense filed an ex parte motion, got an ex parte order to allow them to bring a camera into the hospital. And then the investigator sat down with the defendant and asked him, James, tell us about the shadows that yesterday, or tell us about last night. And then he started talking. That's not someone who's saying nonsensical things at the time that he's talking to the other person. That's an interview, allowing someone to talk about what happened before. That would be no different again than if it happened today. For example, the defense could come in today and say, Your Honor, last night after we left court, we had an investigator sit down with our client, and we had our investigator ask him more questions about the shadows, given what's been going on in the trial or what's been said. And the court should admit this testimony because it's nonsensical and therefore not hearsay. That's not what the Toth case was getting at. That's T-O-T-H. That's not what he was getting at. It's completely different, and it's different than the RICO case as well on that basis. We're talking about an ex parte order that allowed the defense to go to the hospital with a camera and interview the defendant and have the defendant talk about his experience the night before. And it's in that context that then he talks about these shadows. His statements are inconsistent with what he himself said to Dr. Reed. I went back and reviewed the statements that he made to Dr. Reed. Dr. Reed questioned him about the shadows. These statements on this video recording are inconsistent. They contradict what he said to Dr. Reed. They're inconsistent with what he said to doctors at Denver Health Medical Center at the same time, during the same time frame. The very same days that he was in the hospital talking to medical personnel about what he was experiencing and what he was seeing, this video recording contains additional details that are not in there. That's inconsistent. It's not just additional details. The fact that there are additional details to me tells me that it is inconsistent because he never mentioned those details to the hospital personnel, even though they were asking him questions about what he was experiencing, what was going on with him, how he was feeling, those kinds of things. Presumably, if he had said those things to them, they would have included them in their medical records, and they did not. So I do have major concerns about the reliability and trustworthiness of this video recording, and specifically the statements related to shadows. And that's what is most probative to the defense about this video recording. That's why we're all focusing on the statements about the shadows. But in ruling on the admissibility of this particular video recording under Rule 703, I have to look at the prejudicial effect. And I think the prejudicial effect includes the fact that I believe these statements are unreliable and untrustworthy for all the reasons I stated yesterday. Not only because of the defendant's medical condition at the time, not only because the prosecution was not present, not only because this was an interview only conducted by the defense, but for all the other reasons that I have stated yesterday and today. I have concerns about the reliability and trustworthiness of the video recording, and it in my view, has no probative value, none, in assisting the jury to assess the reliability of, or the opinions of Dr. Gurr. Now, if you want to get away from Rule 703 and talk about other rules of evidence, I continue to believe it's hearsay for the reasons Mr. Orman stated, for the reasons that I have stated, and furthermore, it is inadmissible under Rule 403 because the probative value of the evidence is substantially outweighed by the danger for unfair prejudice, confusion of the jury, misleading the jury, all those issues that Rule 403 concerns itself with, or is concerned with, I should say. It is true that the defendant was appears to be hiding under the sheets in the surveillance video that was taken by the hospital the day before, but that is in the medical records. That has come out already. That there's nothing new about the defendant saying that he was hiding under the sheets or the blankets because he was hiding from shadows. That has already been admitted. So to the extent that that's what the defense is interested in, it is cumulative. It has already been admitted. The other parts of the shadow conversation is what's inconsistent with the medical records at DHMC. And I'm not, again, I have some the concerns that I have indicated. In terms of making redactions, that's not going to cure the problem because of all the things that I have stated. The issue is, or the concerns are in particular with the conversation about the shadows. But then you have all this other conversation in any event that includes the investigator's statements. But even if those were redacted, I would have the same concerns that I've talked about with respect to the conversation about the shadows. If the defendant wants to present this evidence, he can present it by getting on the witness stand. He's got every right to do that. He can take an oath and he can testify under oath about these particular statements. I have told him about his right to do that. No one can prevent him from taking the witness stand. I have advised him about that, and I will advise him again about that. The RICO case is in opposite for the reasons I stated. In that case, you don't have a situation where someone on the defense team sits down with a defendant with a camera and says, now, talk to us about what happened last night so that we can then admit this into evidence. It wasn't like that at all. So for all those reasons, my ruling stands. Is there anything else before I bring the jury in?
No, Your Honor.
Anything else before I bring the jury in, Mr. King?
No, Your Honor.
All right, let's bring the jury in, please. Good morning, Doctor. Good morning. Please be seated. Good morning, folks. The record should reflect that the jury has joined us again. How's everyone doing? Good to hear. At the end of the day yesterday, Dr. Raquel Gurr was still on the witness stand. And doctor, I remind you that you're still under oath. Mr. Brockler was still in his cross-examination, and I think he was getting ready to wrap up. And so, Mr. Brockler, you may now complete your cross-examination.
Thank you, Your Honor. Good morning, Dr. Gurr.
Good morning.
We left off as I was going through some of the evidence that you had gone through in the discovery, in the 100,000 pages of discovery that you factored into your decision-making. Do you recall that?
Yes.
Where I left off with was asking you if you recall that you had testified that the defendant told you that he believed that the people that he shot in the theater did not mind and would not have minded being shot. Do you recall that?
Yes.
And you know that the defendant had told Dr. Reed on the videotape that you had watched that he believed that, in fact, from their point of view, they probably wouldn't want to be shot. That's a quote. And then, quote, they probably would mind being shot. Do you recall that?
Yes.
So what I want to explore with you is some of the other evidence that it sounds like you may have gone over with the defendant, although not documented, and I want you to let me know if you did review this with him.
Yes.
That on the night of the shooting, the defendant did not park in front of the theater. Did you talk with him about why he parked where he parked?
Yes.
And the reason that he parked in behind the theater was because he needed an opportunity to change into the rest of his body armor. Do you remember that?
Yes.
And the reason he needed to change into the rest of his body armor was because had he walked into the front of the theater dressed in his body armor, people would not have continued on in their normal business going to sit in the theater, correct?
Yes.
He wanted to hide from them his intent or his thoughts as he went into the theater on that night. You agree with that?
I'm not sure.
Well, let me ask you this. You can think of no reason why someone would need to wear different clothes going into the theater than they're going to use when they commit this shooting, unless it's to deceive the people around him as to what his ultimate goal is. You'd agree with that?
Objection to relevance.
Overruled.
Go ahead, doctor.
I see it as part of the mission.
I understand. But part of the mission then was to deceive the people around him as to what his true goal was coming to the theater, correct?
The mission was to come into the theater and complete the mission to the best of his ability. And
Right.
it included having the armored clothes. I do not believe that its state of mind at that, during those minutes, what will the people sitting there think about? I don't believe that he was capable of going through a deliberate process. At that time, it was part of the mission. You leave at this time, you go this way, you dress, you park, you dress, you go in.
I understand. You would agree that he took steps to not reveal to those who he shot what his plans were when he came into the theater that night.
He took steps to accomplish his mission to the best of his ability, and part of the mission was to be dressed in the attire that we discussed yesterday.
Well, and his goal was to maximize the number of kills he could accomplish. You'd agree with that, right?
Yes.
And if people saw him walk in through the front lobby in body armor, most presumably, and you must have asked him about this, they would have thought, maybe we don't go to the movies tonight. Correct?
Likely.
And then it continues. He dresses himself prior to going to the back parking lot where he had parked with his body armor. He dresses himself pretty much like everyone else. You'd agree?
Yes.
That he goes into the theater and sits down like everybody else, correct?
Yes.
And that at some point he stands up and pretends to have a cell phone call You agree with that?
Yes,
And there was no cell phone call, correct?
yes,
In fact, the cell phone he used was the cell phone stun gun, correct?
yes,
And that he does this to not draw any undue attention to him leaving out the exit door at the back of the theater. You agree?
yes,
And that he had made the decision that, and the analysis, that this door will lock behind me if I don't do something to prevent it from locking behind me, correct?
yes,
And so he had created a clamp off of something he purchased off of Amazon.com and manipulated to keep the automatic lock from happening. You'd agree with that?
yes,
And so when he leaves the theater, you agree that in part his goal is accomplished, that he has left the impression with the theater goers that they have nothing to fear from him, correct?
Objection left the impression with theater goers. Calls for speculation.
I'll sustain it.
Doctor, when he left the theater, you agreed that it was his intention not to cause concern with the other members in that theater right in there, correct?
I don't think that he was going through a deliberate process of thinking it through. At that time, Mr. Joe or this person sitting there might look at me, so it was just an automated way of being on autopilot to accomplish his mission. Can the impression be, did he try to accomplish the mission? And by that, not drawing attention to him so he can accomplish it? Yes, but was he at these minutes thinking, this is what the people think and this is what I should do next? It's not something that I could obtain from him in questioning. He knew what he needs to do, but was not going back and forth and thinking, well, they think this way, so I will think this way. That was my impression.
And then when he got to the car, he put up a sunshade to block anyone's visibility inside the car of him changing into the rest of his body armor and getting himself ready to kill. Correct?
Yes,
And he did that, you must have explored this with him, because he didn't want people to see what he was doing. Correct?
yes,
And that he had heard some noises outside the car. Do you recall that?
yes,
And that it was his intention, had someone tried to see what he was doing, that he would kill them. Correct?
it was, yeah.
One of the other things that Dr. Reed, you'll recall, explored with the defendant, and you may have talked about this with him as well, was to discuss his indifference to the victims. Do you recall that?
Objection to the word was impersonal to her, I believe.
I sustain.
Do you recall Dr. Reed talking with the defendant about his indifference towards the victims?
I remember, I'm not sure about the word indifference, but I remember the doctor, we discussed it, yes.
Do you recall that when he talked with Dr. Reed about the events of that shooting at the time that we've just discussed, that the defendant said, quote, I never, when he talked about the victims being killed and whether they would mind it, that he said in part, quote, I never considered it. He added, quote, I was focused on increasing my own value, not their needs, end quote. Do you recall that?
Yes,
And that when Dr. Reed came back and asked him, is it fair to say you were indifferent? This was in the question. The defendant responded, quote, yeah, that's fair, end quote. Do you recall that?
yeah. So the word indifference came from Dr. Reed and was not from the defense, from Mr. Holmes.
You're correct. It sounds like, based on your answer, that the defendant just agreed that was the right word, correct?
Correct.
And that he went on to say that, quote, just that it, being the shooting, was necessary to do what was in my best interest, end quote. Do you recall that?
Yes,
And then he told Dr. Reed, I guess it would be selfish to do that, end quote. You agree?
yes, within the context of the interrogation
Yes, I
by Dr.
understand.
Reed.
In addition, shortly after the shooting, about 4 days later, when he talks to Dr. Woodcock, you agree that he'd indicated that he didn't want it to happen to him, right?
Yes,
That when Dr. Reed asked him about the selfies that he took, that the defendant told him that more than just trying to show that he could purchase things, he believed that people would remember him as a bad guy. Do you recall that?
Yes.
And that the defendant said, and I don't think you testified that he told you this, but that he told Drs. Metzner and Drs. Reed that he believed it was wrong to kill children. Do you recall that?
Yeah, that he told them in reading, yes.
Yeah, did he tell you it was wrong to kill children?
He did not tell me it was wrong to kill children.
Did you ask him?
Yes.
And what did he say?
He did say that people have different values, and that children have values, and older adults have values, and that the value of people depends on what they've accomplished in life and what is the potential to accomplish in life.
You recall also that your statement that you attribute to him, that he had planned to wound some but not kill, but didn't know that he would kill, that he denied making that statement to you when he talked with Dr. Metzner. Do you recall him denying that?
Yes.
You agree that although he told you that he thought he was, in essence, and this is a word we talked about, I'm not attributing it to him, that he was doing a favor for people by putting them out of their misery, that he agreed with later mental health experts, specifically Dr. Reed, that to kill a person without their permission would be evil.
With Dr. Reed.
Yeah, thank you. That he went into detail, some with you, but more with Drs. Metzner and Drs. Reed, about why he hated people. Do you recall that?
He didn't use the word hated with me. He used the word more anger, and when I explored anger, hate, a little hate, but I agree that with Dr. Reed and Dr. Metzner, he was talking more about hating people.
To be clear then, in each of the interviews that you had, in the 13 hours before you opined he was schizophrenic and insane, and in the 15 hours you had after the first court-appointed psychiatrist opined that he was sane, he never discussed with you hatred of people?
I brought up the topic of anger and hatred of people as I was obtaining information from him regarding the motivation for what he has done. He was afraid of people, he said, but he was not angry. Anger or hatred to people did not motivate him to kill people. It's his increasing his self-worth has motivated him.
Did you have this conversation with him before or after the court-appointed psychiatrist found him sane?
I had this conversation with him every session.
And we've agreed from yesterday that nowhere in your notes or your reports do you indicate a conversation with him about anything regarding hate prior to you opining that he was insane and schizophrenic. Is that right?
Please bear with me for a minute.
Yes, doctor.
On my notes,
Yes, ma'am?
of February 9th, 2013,
Okay.
visit to 4 p.m. in the afternoon, second page, I'm reading from my notes,
Yes, ma'am.
a sense that something has taken over. Did not feel angry, wanted to stop the thoughts that bothered him for years and intensified in high school at about age 14. So
I know that was a long quote, Doctor. I did not hear the word hate or hatred in there, did you?
he did not use the word hate. And when I asked, did you hate the people, I was not angry with the people. And as I stated yesterday repeatedly, I did not write question, answer, question, answer. The word hate was brought up by me because anger, as you know, is associated, can be angry and hateful. It did not express to me hatred toward the people that he shot in the theater. It was impersonal. He didn't know the people.
You asked him specifically about his quote to Dr. Woodcock 4 days after he shot those people where he said, quote, "I hate everybody." You asked him about that?
I do not remember asking him specifically. I do not believe that I had Dr. Woodcock's notes with me. It took a while for Dr. Woodcock at that interview to provide his notes.
You
I believe
recall-
weeks.
Oh, sorry. Sorry, Doctor. I'm sorry, it took weeks for him to get his notes?
That's what I think. I can check, but I did not have his notes before the visit. Before every visit, in the gap between, during the period, as I got information, I reviewed it, and I did not recall going over that, over Dr. Woodcock's notes that were available to me for February 9th. I might be mistaken, but I do not remember that I had it.
And you'd agree that those notes purportedly were taken on the 24th of July, some 4+ months, 4.5 months before you saw the defendant?
Correct.
Okay. You recall going through the discovery, and I want to ask you if you do, and if you talked to the defendant about statements he made to Ben Garcia about disliking the world and the world needing to suffer.
Yes.
And what did he say?
I don't remember the exact words, but they do convey just what you said, that he had difficulty with the world. And I did discuss with him his fear of people and avoiding people and not profound anger with people that permeated on a day-by-day basis. Most of his time was devoted to protecting himself and moving forward, and was not directed until the period building between July 20th, 2012 was more directed towards self. What can I do to continue with graduate school? What can I do to move on with my life? To get a PhD in neuroscience? It was not spent at all from my questioning of what he thought about hating people. And I do not believe that this was the major motive and a major theme in his delusions.
Doctor, you agree that one of the things that was prominent in his discussions with Dr. Reed was his interest and belief that he would be remembered for what he did, correct?
During the questioning, yes, it's something that he was questioned about repeatedly, and it's something that he said, it did not convey that to me.
Understood. Also, the compulsion that you've tried to describe here, first off, you would agree that that compulsion was something he was able to keep at bay until he'd had his complete plan in place to go commit that crime on July 20th. Fair?
Just from my perspective on it, I can't answer this yes or no.
Okay, that's fair. Here's what he didn't do. When he felt what you've described and you alone have described as a call for action, He didn't go to a gun store, buy an AR-15, go to the movies right then and there, displaying the AR-15, walk in and just shoot everybody in the theater. He did not do that, correct?
Correct.
One of the other things that he told Dr. Reed, that he thought that killing people was going to make his life more meaningful. You recall that?
Yes.
And that the thoughts of killing people brought him hope and gave him a purpose.
Yes.
That as he planned to kill people, he didn't feel so depressed.
Yes.
That Dr. Reed specifically asked him about this idea of a master anything, moving him in a particular direction to do things, and that the defendant replied, quote, "No, I'd say it was my own authority," end quote. You agree with that?
Judge, I would object to the master anything. I don't recall any question like that by Dr. Reed.
Overruled?
Go ahead, Doctor.
I do not remember the word master as well, but I trust you that it is in the record. And I will say to that a consideration needs to be made on the fact that he was now medicated for 2 years and stable, and the information that I obtained from him was much earlier in the course of his illness compared, and by the time he met Dr. Reed, he's gone with multiple professionals over the same information again and again, and was on a stable dose of antipsychotic and antidepressant medications, and this needs to be considered in the responses as stated repeatedly by Dr. Reed himself.
You met with him in November of 2014, correct?
Yes.
Well after Dr. Reed had met with him, correct? Correct?
Yes.
And you took notes indicating that you felt that his statements at the time were consistent, correct? With what you'd gotten before, correct?
Yes.
He being the defendant, never said that he was responding to a command hallucination, correct?
Correct.
That he wasn't directed by God to do what he did, correct?
Yes.
That he didn't say that he was doing this for some noble purpose, like trying to save the world or prevent a world disaster, fair?
Yes.
You know what, I forgot to ask you a question yesterday, ma'am, about this defendant's TR 94. Remember the jail writings that we talked a little bit about in terms of how they were set out?
Yeah.
What? May I approach, Your Honor, the evidence table?
You may.
I'm handing you, ma'am, that exhibit. Do you recall
thank you.
that?
Yes.
You'd agree that that was written by the defendant after he was arrested?
Yes. When in jail.
When in jail?
Yeah.
By the way, do you know when he wrote that?
I do not recall.
It was after he'd been arrested for these significant crimes, correct?
Yes.
And at a time when it would be obvious to anyone that they were facing significant criminal proceedings for their conduct, correct? Correct?
Yes.
And that it wasn't a secret to him that things that he generated might be seized from his cell, correct? Correct?
Might be, yes.
Or in this case, generated and provided to defense counsel by him. Do you recall that?
Objection. That misstates the evidence, Your Honor.
Overruled?
Go ahead.
So I was not aware that it generated a war. I mean, when you ask, might they be, might he be asked to provide them when his cell is checked or can be looked at? Yes, but I was not aware that I was not aware the defense counsel has asked him to write and produce this document.
No, what I'm asking you is, he would be aware that he was able to generate writings and provide them to counsel, or that they could be taken from his cell, that sort of thing, while he's awaiting charges and criminal proceedings. You know that, right?
Judge, objection. May we approach?
Yes. All right, Mr. Brockler, you may proceed.
Thank you. Doctor, I want to ask you just a couple hypotheticals in light of some of the discussion that we had a couple days ago about the cognitive impact of schizophrenia or any mental illness, okay?
Yes,
Now, you'd agree with me that we infer brain function from behavior, correct?
yes,
And that the behavior, complex behavior, is a product of brain function and we infer it by observations, correct?
in the clinical setting, yes,
Sure. So one of the things that we talked about was the ability to absorb information, to interpret it, make decisions upon it, and paying attention, shifting focus, all those things. Do you recall that?
yes,
And you would agree, and we've heard testimony from the state, actually even the defense psychologist, that those functions are the highest order of brain functions that we have, those executive decisions, correct?
yes,
So I want to give you a hypothetical and ask if this supports the idea that someone has the ability to do all these things, okay?
yes,
Guy's driving in the mountains. He gets pulled over by the police. In the course of the contact, the officer that comes up to the side of the car looks in the back window of the guy's car and he sees guns, gun cases. And he asks the guy who's driving about them. That guy doesn't want people to ask him questions about the guns in his car. He goes home, he gets online and researches window tinting laws for Colorado, goes out and buys window tinting, applies the window tinting to his car, and now no one can see the guns in his car. With that hypothetical, those facts, you would agree that that is indicative of someone who has a pretty high level of executive functioning based on the definition we just read out of your book.
Judge, I'm going to object that this calls for speculation and is irrelevant.
Overruled?
Go ahead,
It
Doc.
is, the objection on relevance is overruled. The objection as to calling speculation is overruled because it's a hypothetical opposed to an expert.
Go ahead, Doctor. And do you need me to rephrase the question?
no, 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 I know my book.
Okay.
It does reflect on the ability to plan, but I will not to plan, but I will not call it. I mean, you were describing it as I heard it, that this is the highest level of complex behavior. To go online and check on law requires ability, but I was hesitating because I don't believe that this is the highest level of complex behavior. It requires executive function, yes, but it is not a classical example that I will use. But I agree with you, it requires planning.
Well, more than that, I just want to read you the words here, and you tell me if you think that that hypothetical fits. The ability to absorb information, correct? That demonstrates the ability to absorb information, correct?
Yes,
To interpret the information, correct?
yes,
And make decisions upon it, correct?
yes,
And keeping learned information in mind and then using it right away. You agree with that?
possibly,
Okay.
the last part, yes,
Let me give you another hypothetical.
yes,
Guy wants to have something happen at his apartment with fire. You can call it incendiary, explosives, whatever. And he wants to do it to keep law enforcement officers, specifically police officers, from arriving to a theater where this person is going to try to kill a bunch of people. Okay? Fair? This person in this hypothetical doesn't know how to make bombs innately. They go online and they research it. They then find out that they can do it with things called potassium permanganate, glycerin. They find out how to make thermite. They find out how to make napalm. They make multiple trips to acquire each of the subcomponents of this, and they spend considerable time making it. Then they think, if this catches on fire, who will come to put it out? Firemen. And firemen will use water to put the fire out. So this person thinks, I need magnesium to keep the fire from being put out.
Judge, I'm going to object at this point. This is not a hypothetical. To call this a hypothetical is a charade.
The speaking objection is overruled, Mr. King. Overruled. Go ahead.
So this person thinks, I need something that won't be put out by fire. I need magnesium. And so they go out and they get magnesium and sprinkle it across the floor of their apartment where the fire will be. But they also think, I'm not worried about distracting firemen. I'm worried about distracting policemen. So in addition to the fire that can't be put out with water, they put bullets in napalm that they've made, in black gunpowder that they've made, so that when the bullets go off, it summons police. That, to you, doctor, you would agree, would indicate the ability to absorb information, yes?
Yes.
Interpret information, correct?
Yes, if you're meaning the sense of being able to read off the internet and follow directions.
Well, and more than that, even more than this definition, that hypothetical indicates a person who has the capability to think 2, 3, 4 steps down the road in terms of cause and effect. You'd agree with that?
Yes.
That they have the ability to make complicated decisions, correct?
Yes.
And then to add into that hypothetical, they then decide that it is important enough to want this fire, this explosion, this event to occur, that they don't rely on one method to trigger it, but they have 2 separate methods to trigger it. You would agree with that?
Yes.
All of that is suggestive of someone who has a very high level of executive functioning, correct?
Within high level of intellectual functioning. Yes.
And executive functioning,
Yes.
correct. All right. Now I want to ask you about another hypothetical in terms of the ability to shift focus and make decisions in the spur of the moment, okay?
Yes.
A guy thinks that they've had this distraction go off in this hypothetical. They're in a theater. They've shot as many people as their AR-15 or their whatever kind of rifle it is will shoot. And they go outside. And they go outside and they see a police car and they see 2 police officers at either ends of the parking lot. They hear sirens, many sirens. And they stop and they look around and they make an assessment that I'm not going to be able to drive away. I don't have the time to change out of my body armor. It's a matter of just seconds until they figure out who I am. And they put their gun on top of the car with Vicodin coursing through their body with an attempt to not be shot and not be hurt in any
Judge,
way.
I'm going to object to this narrative question. This is not a hypothetical. It calls for speculation. It's putting thoughts into the person's mind that are not in evidence.
The objection is overruled.
Doctor, I'm asking you if that scenario, that hypothetical were true, you would agree that that person, even in that moment after the shooting, has demonstrated the ability to take in information, correct? Correct? They've demonstrated the ability to take in information, correct?
Yes.
Interpret that information, correct?
Likely.
And make decisions based upon that interpreted information, correct?
I've gone over it with Mr. Holmes, and when, the detail that you broke it down of him coming out, seeing the police, surveying the police, sitting, and it was an automatic response.
You
It was
understand?
an automatic response. And if you say, if you ask me, the way you describe it is like minutes went in an extensive, deliberated process of this is what I'm going. This was not what I obtained from him. It was an instinctive response of fight or flight. You're going to fight it, or you're going to move away. You're going to lift your hands up and surrender. But in the hypothetical that you gave me, I thought that the two previous examples, it's now the third, were more reflective of a process over time that takes the ordering, the preparation, the reading, the information. I do not see this last decision that you provided as reflecting of high-level executive processes.
You would agree that none of that appears in your notes or your report of June 2013?
Objection, Judge. This is a hypothetical question. How could it appear in her notes?
I'll sustain it to the form of the question.
You remember that you've just told us that you had a conversation with the defendant about his decision-making process when he left the theater. Did you just testify to that?
Yes.
Now that's separate from the hypothetical I asked you, but I want to make sure before I move back to the hypothetical I asked you, you agree you don't put in your report of 2013 or in any of your notes that discussion that you had with the defendant?
We have discussed already the nature of my report, and we have spent a day of you saying what I didn't put in the report rather than what did I put in the report, and that's why I'm here, to present and explain to the best of my ability under oath what is the information and what was the basis for my clinical decision. So we can go over what did you put and what you didn't, and we'll save a lot of time to the court.
Did you understand my question, Doctor?
I understand your question.
And the answer to my question is no, I didn't put that in my notes or my report. Is that fair?
Correct.
In fact, what you want to say is I picked and chose what I thought was important to put in the report, and that's what we spent yesterday going over. Is that fair?
No.
You did not pick and choose what you put in your report. It put itself in there.
No. I mean, of course, I wrote the report, but what I chose to put in the report is what I was trained to do, provide the basic information briefly. We don't weigh the report on the scale. This is heavier. It means that it is more veracity. And it was relying on over 30 years of my professional experience in evaluating people. So what I put in the report was a condensed communication that I believe will convey to the court what is pertinent from my perspective, and the rest I can answer. So I didn't write, as I said, repeatedly, and I can answer it from now on if you ask me what is there and what is not. Yes, no, yes, no. We can.
Doctor, in answer to the hypothetical question, you'd agree with that hypothetical question, that person in that hypothetical, given the facts that I've given you, that person would have demonstrated a high level of executive functioning, correct?
For the third example, no. And it's not an hypothetical. You're asking me a question that I went over with Mr. Holmes.
Your Honor, I'm going to move for the admission of People's Exhibit 1260 and 1261 into evidence. May I have a moment?
Yes. Is there an objection to 1260 and 1261, P-DR-1260 and 1261?
Yes, Your Honor. Hearsay.
Right. I will defer ruling on that. Are you, Mr. Brockler, do you have any more questions?
I do not, Your Honor. Thank you.
All right, Mr. King, do you have redirect?
Your Honor, may I have a moment?
Yes. While Mr. King is doing that, members of the jury, let me just remind you of something. Every once in a while, you may hear objections to mischaracterizes the evidence, or facts not in evidence, or misstates the evidence, things along those lines. If I overrule those objections, it doesn't mean that I'm disagreeing as to whether it misstates the evidence or not. I'm overruling it because it's up to you to decide what is the state of the evidence. You decide what facts there are. Of course, you don't do that until the very end because you can't start deliberating. But that's your job. So if I overrule those objections, that's why I'm overruling them. You should not take my rulings on those objections to mean that I have a position on what the evidence is or what the evidence isn't. That's, you got to rely on your recollection of the evidence for that. Does everyone understand that? Okay, and everyone's saying yes and nodding their head yes. All right. Thank you. Mr. King, you may proceed with your redirect examination of Dr. Gurr.
Thank you, Your Honor. Doctor, that last couple of questions reminded me of something. A large portion of the questions Mr. Brockler asked you yesterday began with the phrase, "You would agree with me." Do you agree with the way Dr. Brockler, do you agree with the way Mr. Brockler is framing these issues?
Sustain.
Do you agree with Mr. Brockler about these issues?
Objection to the form of the question about how I'm framing it.
Well, this one is a different question, but I'm going to sustain the objection as to the form of the question. I'm not sure what it means. So rephrase your question, please, Mr. King.
Is Mr. Brockler a psychiatrist?
Objection to relevance, Your Honor.
Overrule. If she knows, I don't know whether she knows or not.
Do you know whether...
She knows. He's not.
In order to render the opinions that you're rendering here today, how long have you been practicing psychiatry?
Since 1980, as a psychiatrist, since during my training in 1984, upon completion, also part, but totally psychiatry upon completion of my neurological training.
Now, you were asked a lot of questions about different times. You were asked questions about the Billiot case, where the video recording took place. Do you remember that?
Yes.
You remember in the Billiot case that the court noted that you had an extraordinary ability to get information from that psychotic defendant that other psychiatrists did not?
Sustain us to hearsay.
I want to ask you some questions about your work that you did on this case and about the documents that you presented. And in doing so, I would like to focus not on form, but on substance. Not on grammar, but on what your actual opinions are about this case, if I may. You were asked questions about the MRI. Do you remember that?
Yes.
Tell us about the MRI. Are there two different kinds of MRIs that were used? One to do the imaging on Mr. Holmes here in Colorado, and one to do the imaging on the normal people that were tested in Philadelphia?
Yes.
And was one more sophisticated than the other? I don't know. Just let us know.
The resolution of the images at the University of Pennsylvania Hospital with a 3T magnet has better resolution than the 1.5 magnet that where the MRI was obtained in Colorado.
So like a sharper focus or something?
Yeah.
Now, tell us how that affects the comparison. How does it take place? There are the two images, and then is there a computer that actually analyzes the two images?
All is done by computer without any human interference, with no identity of the person. The MRI gets a number. It's all automated, validated, published procedures that are accepted in the scientific community.
Is there any reason to doubt that because these two machines have different resolutions, that there's any invalidity to this comparison, or is that just a complete red herring?
Sustained.
Is there any concern about the validity of this comparison, or not?
No, the method that is developed is high level of reliability, namely, if you do the same analysis again and again and again, it's one method of reliability. The other one is you take one subject out and you repeat it, and you do it permutation, thousands of times, you come up with the same value. So it's reliable and it has been validated. However, I'd like to note that I did not make the clinical diagnosis of Mr. Holmes on the basis of the MRI.
Okay? And why is that? Is it not a diagnostic tool?
It is currently not a diagnostic tool for schizophrenia. While in a published paper in 2006 in the leading psychiatric journals, Davatzikos et al., and I'm a co-author on the paper, show that if you take a large group of people with schizophrenia and a large group of demographically matched, same background, same age, same level of education, healthy people, the computer will differentiate an 80% accuracy.
880?
80 about these people have schizophrenia and these people do not. Yet, it is not a diagnostic tool, and I did not base my clinical decision or opinion based on the MRI.
So is 80% not good enough to use as a diagnostic tool? Is that what you're saying? That it can only get it right 80% of the time if you use that solely as the tool to diagnose with?
Sustained.
Is that the case, or is it not the case?
Yeah, it's not the standard. I mean, it's something that is being investigated. There are thousands of papers worldwide on the topic, but it is not a clinical diagnosis yet.
Okay. Let's talk a little bit about, you were criticized, I think, for the timing of when this MRI was done. Let me ask you a couple of questions. Was the results of the neuropsychological testing, both sets, done by Dr. Hanlon and Dr. Manguso, which showed that dramatic drop in IQ that Mr. Holmes has sustained over the past 2 years when he was incarcerated. Did getting those results cause you to think that maybe we should think about getting an MRI to see if we could confirm those results with an actual picture of Mr. Holmes' brain?
Yes.
Sustained.
Did that play a role, or when I ask you, was this something that played a role, do you understand that to be a question you can answer yes or no? Or am I asking for a specific answer?
Yes.
Now, yes or no, did the results of the psychological testing cause you, yes or no, to think that it might be a good idea to take a picture of Mr. Holmes' brain to
Yes.
corroborate those test results?
Yes.
Is there a blood test or a DNA test or any other way that we can tell for sure what the diagnosis is?
No.
Prior to even getting those neuropsychological test results, had you already met with Mr. Holmes several times?
Yes.
Had you already asked him many, many questions about his presentation and his history?
Yes.
Had you already come to some kind of a diagnostic formulation in your mind?
Yes, after 13 hours of interviewing him.
Now, the CAT scan. Are you aware of whether or not a CAT scan was performed on Mr. Holmes' brain when he was hospitalized in November of 2012?
Yes.
Was that CAT scan performed in your review of the records to see if he had a lesion from hitting his head on the wall or not.
Yes,
Did the clinical review of that CAT scan review that there was no bleed, no lesion, no broken skull?
yes.
At some point in time, were we able to actually get our hands on the picture itself? Not the report from the hospital, but the actual CAT scan itself.
Overruled. You can only answer if you know. If you know. I don't know if you know the answer to the question. Don't speculate.
I know, yes.
Previously, was it the information that you were operating under that there was no picture that existed, but they'd written a report and the picture had been deleted?
It's a possibility. Hospitals do not store all, clinical data for a long time. Hospitals vary, and sometimes you can't obtain it.
Did we find on late in the case, early in 2015, that in fact this CAT scan still existed? Do you recall that?
Yes?
Yes. All right, Mr. King, you may proceed. Why don't you ask the question again, Mr. King, so that Dr. Gurr is clear on what the question is.
Did we find out for the first time late in the case, earlier this year, that there, in fact, the CAT scan did in fact still exist?
Yes,
And when you found that out, did you want to see it?
yes,
And did you look at it?
yes.
And what did you notice when you looked at it, based upon your 30 years of experience in neurology and psychiatry?
That there was slight dilatation of the ventricle.
And you've explained the ventricles, I think, as the, and correct me if I'm wrong, Dr. King may be wrong about this, the empty spaces in the brain containing the spinal fluid that the brain bathes in, as you say? Is that the ventricle?
Yes,
And so what would the ventricles look like to you?
butterfly. Like,
Okay.
and they looked slight, and I say slight. Dilated slightly, slightly, according to age, slightly.
Okay. And when you say
Larger.
according to age, do you mean for someone Mr. Holmes's age?
Yes,
They were larger slightly than you would expect.
slightly.
Okay.
I did not attribute clinical significance, much clinical significance to that.
And can you not attribute clinical significance to that because of the nature of a CAT scan not being as sophisticated an instrument?
Yes, it is not optimal for that.
Was that the reason or not that we then decided to do the MRI when we did it?
Yes,
You were asked a lot of questions about your report, your reports and your notes. You were asked about grammar, you were asked about quotation marks, and you were asked many, many questions about when you wrote what on which piece of paper. Does any of that affect any of your opinions in this case?
not.
Were you ever under the impression, or would you ever operate under the thought that your reports or your notes were the way you were going to deliver your expert opinions to this jury
No,
or this court?
no,
Did you always think that the way that you would, or not, did you always think or not that the way you would deliver your opinion to this court would be in the form of live testimony?
yes,
Did you anticipate that as a result during that live testimony that Mr. Brockler would have the opportunity to ask you any question that he wanted to about your findings, about the substance of what you're saying was going on in Mr. Holmes's brain? Was that your understanding?
yes.
How many questions do you remember from yesterday that actually related to the substance of your opinions?
Sustained.
Do you remember any questions about the substance of your opinions from the course of our proceedings yesterday?
Sustained.
You know, I was not.
Hold on, I sustained the objection, Doctor, sorry. Go ahead, Mr. King.
Thank you. Does anything about the way you wrote your reports, or what you put in your notes, or what you did not put in your notes, or the punctuation that you used, affect what Mr. Holmes' mental illness is somehow?
No,
Does that mean that he's faking his mental illness?
no,
Does that mean that you're making something up and lying to this jury about
No.
what your expert opinions are?
no,
Would you do that?
Abs-
Would you stake your reputation and put it on the line and testify falsely in a case of this magnitude?
absolutely not.
You were criticized for writing, supposedly, an article, a peer-reviewed research article, once per month, I think was the math that Mr. Brockler did. Do you have any commentary on that?
Sustained.
Do you write all those papers entirely by yourself?
No.
Why?
The process of publishing a scientific paper in a refereed journal follows very strict guidelines. The journal dictates the length of the paper, brief, the number of words, the formats, and for each author on the paper, a justification and a signature of that author as to what they have contributed to the publication. Between 2005 and 2015, when records, national records are available, and I have the link if you'd like to, I've published 209 peer-refereed papers. I am first author, the leading author, the one who designed the study, collected the data, analyzed the data, presented it within the context of the literature as required by the journal on 6.22%. I wrote the entire paper. I'm last author, senior author, the one who provides the conception, the funding, and directs a team. And as I mentioned, we have a very large team with complementary expertise on 12 of the 209, 6.22%. The first author, 6.22, I'm sorry. Last author, senior author, 42 out of 209, 20.57%. And then you can be second author. The closer you are to the first, the more your contribution. And I can break it down, and I just don't want, I want to save the court the time. This means that I have published, written my paper from beginning to end, 1 to 2 per year. The number that was provided reflects on multiple people in our program, faculty members, fellows and trainees. This is how you teach them with a federal government training grant, and you train them how to write. It's like postdoctoral fellows, graduate students. You have to learn, and I've supervised them. I've mentored many, many people who now have faculty positions throughout the United States and abroad.
Okay.
And have also participated in multiple studies. Genetic studies require very large samples. And in some of the papers, there can be 30, 40 authors. So the sum reflects the requirement for high quality science that I participate, I am proud to participate in, but I do not produce myself every month a paper. It's not feasible.
Okay, thank you. You were asked by Mr. Brockler about a certain percentage of the people with schizophrenia who are, quote, intermittently untreated and unmedicated. And I think that is that true, that there are a certain percentage of people with schizophrenia that are intermittently untreated and unmedicated?
Yes, not on the choice of a psychiatrist. It's people do not adhere to the medication and take themselves off the medication.
Does that in any way affect this case or your opinions about Mr. Holmes?
No, it doesn't. Me-
Your notes. Did you ever believe, I asked you about your reports, did you ever believe that your clinical or scientific opinions would be presented to this jury via your notes? Did you think that or did you not think that?
I did not think so.
Did you nevertheless provide your notes to Mr. Brockler when requested?
Yes,
Did you agree to meet with Mr. Brockler for hours on end over the telephone to
Yes.
discuss your notes?
yes,
Did you go through with him your notes bit by bit?
yes,
And the part that we couldn't get to, the last visit from November of 2014, did you assist us in translating those notes in a written to a typewritten format and approve that for Mr. Brockler?
yes,
When you write down notes in your vast experience as a psychiatrist, is the purpose of the notes to write down every single question you asked and every single answer that the patient gives?
no.
Why not?
It is not the common practice in medicine to provide a verbatim. I asked the patient and the patient said, in fact, what you are trained is to provide the essence and be ready when asked to elaborate or to justify, to explain, do it in presentations orally and not to write voluminous pages. It's just not the practice.
Is that why your expertise and other psychiatrists' expertise are important? To sift through what's important and to then present that to the jury in the form of your opinion or to anyone else in the form of your opinions and your diagnosis.
Yes,
Sustain.
Is that or is that not the case?
it is the case.
Is it or is it not the case that you take notes, and tell me if I'm wrong, to jog your memory, to refresh your memory about the actual conversations that you had with the patient?
Yes,
So do you write down key phrases that then refresh your memory about the conversation and you use that to form your opinions in your report, or not? Or not? Is that the case or not?
yes,
If you were to write down every question and every answer that you asked and every answer that Mr. Holmes gave in this case, would your report have been, how long would it have been, do you think?
well, I've interviewed the total hours I spent with Mr. Holmes is 28.5 hours. I do not believe that if I would have been sitting down and writing every word that it would have been feasible. And in his case, and as is the case with other people, early in the course of psychosis, it is important to pay attention to them, to watch them very carefully, to come back at questions. You have to be, it's like, you have to be on your feet to be able to pull more information, to come at it at different angles, and doing it for hours wouldn't have provided me with the ability to get the essence and really the important information that is pertinent to a diagnosis of a person, any person, especially the complexity of Mr. Holmes, I think it's just not feasible.
Is it important as a psychiatrist when you're forming a diagnosis or rendering opinions that you consider the totality of the information that you have and draw your opinions and diagnosis from the totality of the information that you have?
Yes.
Is there a danger or not in selecting specific pieces of information and placing more importance on those pieces of information than others? Or is it important to consider the whole forest?
It's important to consider the whole forest and communicate briefly the major points that are pertinent to providing, to opinionate on the diagnosis and state of mind of a person.
Mr. King, would this be a good time to take our morning break?
Sure.
All right. Members of the jury, let's go ahead and take our morning break. Please make sure you comply with all my admonishments during the break, and I'll see you back here in 20 minutes. Thank you. The record should reflect that the jury has exited the courtroom. Everyone may be seated. What's the people's response to Exhibits P-TR-1260 and 1261, and specifically the objection on hearsay grounds?
Your Honor, twofold. One, this is being offered under 703, but beyond that, the court will recall yesterday that the witness testified that this was something she believed that she had reviewed and considered. She did think it was relevant, although she didn't put a ton of weight on it, on the issue of whether or not the defendant was making efforts to initiate social contact even during the period after his leaving grad school and breaking up with his girlfriend. It also serves, though, the additional purpose of impeaching her competence and the level at which she investigated this particular issue of his efforts to maintain social relationships in spite of the fact that she concluded he was withdrawing from society, because she indicated despite having this, despite seeing this, she did not go into it with the defendant because she did not think it was important. So, Judge, under 703 and beyond that, to impeach her, in essence, with 703 is why we believe it's not applicable as just simple hearsay.
All right, thank you. I don't think that sufficient foundation was established with respect to Rule 703, and I incorporate by reference my discussion of Rule 703 and what is required from yesterday. So, and that was from my ruling on D-TR-97. As to impeachment, it sounds that that is anchored in Rule 703 as well. The argument with respect to impeachment. And again, the foundation is lacking. I do think it was appropriate to ask her questions and to attack the reliability of her opinions by using the information on the exhibits, which she indicated she was aware of and had reviewed, but that doesn't make the exhibits admissible. So the objection on hearsay ground is sustained with respect to both of them. All right, enjoy the break. I'll see you back here in 20 minutes. The court will be in recess. Thank you. Yeah, of course. Do it later. Thank you.
Please, Your Honor.